Morning, everybody. My name is Maria Weeks. I am the. Yeah. Maria Weeks. I am the magistrate judge this morning. We are here for a determination of probable cause. This is not your trial date, and I'm likely not your assigned judge. If I do find that there's probable cause for your arrest, I will set a reasonable bond with any reasonable conditions, and then you will get a new court date to see your new judge, if it is not a case that we can resolve today. All right, so Philia Christensen.
All right.
Right. All right, good morning, Ms. Christensen. You were arrested for battery, domestic violence. I do find probable cause for your arrest. I'm going to set a $2,500 bond with a special condition that you have no contact with the victim in this case.
Judge, when it comes to Miss Christensen, reading the probable cause affidavit, it's lengthy, but I don't actually see where there's an allegation that Miss Christensen really hit anybody. I know there's a lot going on in this probable cause affidavit, but I don't see where there's the actual allegation that Miss Christensen hit the alleged victim or anyone. Beyond that, Miss Christensen has no Florida priors that I'm able to see. Because of that, I was going to ask for standard pretrial for her.
State. All right, and I do see that on the video surveillance, it looks like it was observed that there was an altercation, so I'm going to set a $2,500 bond with no victim contact.
But, Your Honor, when it comes to the video, I'm going to read it. At this time, Gonzalez walked out of his property and confronted her, to which a verbal altercation with Francois began. She's not Gonzalez. That there were multiple people there. I just don't see the allegation where Miss Christensen in this PC allegedly did anything. I know they mentioned the video, and there was apparently 3 or 4 other people, but the officer doesn't mention that Miss Christensen did it.
State, I believe defense counsel is correct. I don't see anywhere in the probable cause affidavit that it indicates that Christensen. Okay.
It's unclear of who. The officer said that it's Miss Christensen before us who has the bloody nose.
Correct. Okay. I'm going to give, I'll give you, state, 24 hours to perfect the PC at this point.
The only issue with that, Judge, is ostensibly Ms. Christensen's going to be held no bond for the 24 hours. Even though this is a bondable offense, I would ask for, if you're not going to put her on standard pretrial, I still would ask for a convenience bond to be set for the 24 hours.
Okay, I'll set a $2,500 convenience bond in the 24 hours, and I'll give the state an opportunity to perfect.
I'm going to ask for a photo order.
Yes. Okay, next is Lakeithra Shanae Smith.
Your Honor, Cletty Simondare from the Public Defender's Office. We actually have 2 medicals, Mr. Horn and Mr. Cullenor. They're both on page 10 of my docket. If we could do those first.
Okay. I'm sorry, what were their names again?
Mr. Horn, he is on page 10 of my docket. Dudley Horn.
All right. All right, I have Mr. Dudley Denoon Horn.
Yes, Your Honor, he's coming.
Okay.
Mr. Horn.
Is he at Maine?
Yes, Your Honor, we're here.
Okay. Yeah. Oh, sorry. All right. All right, Mr. Dudley Horn, you were arrested for a violation of injunction of a protective domestic violence order. I'm going to find that there was probable cause for the arrest, and I'm going to set a bond at $5,000 with a special condition of a pretrial level 2 with a GPS monitor and no victim contact and no return to the incident location.
Your Honor, that seems extremely excessive. He's a 53-year-old man. He's been here in Florida. The total of those 53 years, he works as a bartender. He does have family in the area, but there's no way that they could pay that. They could pay up to a $1,000 bond. He's also, there's pictures, he's been hurt, so he needs an order for photos. His priors are nothing like this charge, and they were 20 and 10 years back. We're asking for a $1,000 bond, otherwise he's going to just be held in here as if it were no bond.
Okay. He can have a hearing in front of his assigned judge at this point, based upon the allegations in the probable cause affidavit, that he had violated the injunction several times in the past and will continue to do so. I believe that that bond is appropriate in the case. Okay. Mr. Jean Clauternis Fellinor.
Yes, Your Honor, he's here.
Okay. Mr. Jean Fellinor, you've been arrested for a battery for domestic violence. I do find probable cause for your arrest. I'm going to set a $2,500 bond with a special condition that there be no victim contact.
Your Honor, he's homeless at this point. He's been in South Florida for 17 plus years. He has been employed at the 7-Eleven and has been working really hard. There's concerns about his mental health and medical health at this time. If we could please set it down to $1,000 so he can get out and get help for his medical and his mental health issues. Otherwise, again, he's going to be just held here, no bond. If we could set it for $1,000, then it's a possibility that his cousins and his sisters could put down the bond, please.
Okay, I'm keeping the bond at $2,500 with the special condition of no victim contact.
Your Honor, he's also just had a newborn, if there's any way that we can bring this down.
I believe that $2,500 is appropriate. Okay,
Thank you.
all right. Lakeithra Smith? Is that? All right. Ms. Smith, you were arrested for aggravated assault with a deadly weapon with a domestic violence. I'm going to find probable cause that that there was probable cause for your arrest, and I'm going to set a $5,000 bond, special condition, no victim contact.
Your Honor, Ms. Smith is on disability. She's been in South Florida for 31 years. There's no way, again, that she would be able to pay a $5,000 bond. If there's any way we could even just split the difference, go to $2,500. Because, they're eligible for reasonable bonds. The indigent are indigent. They don't have money. So if we could please bring this down.
Okay, I think based upon the allegations and the information, $5,000 is appropriate. So I'm keeping a $5,000 bond with no victim contact. All right, next, Jacqueline Agosto.
Your Honor, she's here.
Okay, Good morning, Mr. Gosto. You were arrested for aggravated battery with a deadly weapon based upon the probable cause affidavit. I do find probable cause for your arrest. I'm going to set a $5,000 bond with a special condition that there be no victim contact.
Your Honor, Ms. Augusto has been here for 13 years. She has serious mental health issues that she's dealing with at this time, including schizophrenia. She has 3 children. She lives with her mother. This is a first offense. $5,000 is an extreme amount. Can we please bring that down?
Okay, based upon the probable cause affidavit, I believe that $5,000 is a reasonable bond, so I'm keeping the bond amount as is. All right. Chandrika Brinson. Chandrika Brinson?
Yes.
Okay. All right, Ms. Brinson, you have a violation of probation that was signed by Judge Melinda Brown, and she said it, no bond, so I'm going to keep it no bond. You have a future date to see her on January 22nd at 9 a.m.
Okay.
Jasmine Roberts?
Medical reset.
Okay. Kathleen Mason Mills.
North Broward.
Yes.
Okay, Miss Mason Mills, you were arrested for trespassing of an occupied structure or conveyance. You currently have a $100 bond set.
Judge,
Yes,
Judge, if you can actually hit the sidebar button, I just want to address something that Ms. Millis told me. I just don't want it to be broadcast.
yes.
That information. I'm just asking Your Honor to put her on standard pretrial for her to check in person tomorrow, and then by phone going forward, given her lack of priors and the charge.
Okay, I'm going to put her on standard pretrial. And then you're asking for her to appear in person or by phone? Okay, and then she has to call in by phone once a week. ROR. To pretrial. Okay, all right. Mason Mills, you have to check into pretrial tomorrow, and then after that, you have to check in by phone once a week, okay?
All righty.
All right,
Thank
thank you.
We done?
All right, Brianna Ashley Hunter? All right. All right, all right, Miss Hunter, you have you've been arrested for possession of cocaine. I do find probable cause for the possession of cocaine. You also have an out-of-county no bond hold from Palm Beach for a carjacking with a firearm. So I'm gonna leave the $1,000 bond on the possession of cocaine, and then you have the out-of-county hold.
Judge, I would just request for her to be ROR on count 1 right now, for her to be brought up to Palm Beach, because what will happen ostensibly, the state's not going to file in 33 days on the drug charge, and so she's going to get ROR'd on day 33 and brought to Palm Beach at that point. I'm just asking her for be ROR'd on the Broward case now.
Okay.
Seems like she has bigger fish to fry in Palm
All right,
Beach.
I'll ROR you on the possession of cocaine, and then you will be probably picked up by Palm Beach to deal with that, okay? Have a nice day, man.
Thank you.
All right, Portia Hunter? All right, good morning, Miss Hunter. You were arrested on a burglary of an unoccupied conveyance, petty theft, criminal mischief, and throwing a deadly missile onto a dwelling, building, or an aircraft. I do find probable cause for your arrest. You already have a $100 bond on the petty theft and the criminal mischief. I'm going to set a $2,000 bond on the burglary of a conveyance, and then a $1,000 bond on the missile into a dwelling. And then special condition that you have no victim contact if you do post bond.
Okay.
All right? All right, Teresa LaKay Montgomery.
She's approaching, Your Honor.
Okay,
Remain.
thank you. Oh. Good
Your
morning,
Honor,
ma'am.
we we would like to know if it's possible to resolve, counts 1 through 4 with time served.
I would not advise it with the felony charges pending.
No.
Okay,
and-
they're felony, okay,
Well, the other ones are
Yes.
felony.
okay,
All right,
so
okay.
that's fine.
You already have on counts 1, 2, 3, and 4, you have $100 bonds. And then on counts 5, 6, 7, and 8, you have $1,000 bonds on each one. I do find probable cause for the arrest. I'm going to maintain the bonds as said.
Your Honor, on the first 4 charges, if we could please bring them down to $25, so it's possible that she can eventually afford them, given the amount of charges here.
Okay, at this point, I'm going to maintain the bonds as is. All right, Alexis Nicole Gant.
No problem, John. Morning.
Good morning. Ms. Gant, you were arrested on criminal mischief over $1,000 and throwing a deadly missile into a dwelling, building, or aircraft. I do find probable cause for your arrest. You already have a $500 bond set on the criminal mischief. I'm going to set a $1,000 bond on the throwing the deadly missile. Okay, and with a special condition of no return if you do bond out. Okay, thank you, ma'am. All right, Carla Marie Myers.
Ms. Myers is approaching.
Okay,
Good morning.
good morning. All right, Miss Myers, you were arrested for battery on a person 65 years or older and a misdemeanor battery. You also have a violation of probation in front of Judge Lynch. I'm going to set a $2,500 bond on count 1 and a $500 bond on count 2. You have a no bond hold on your violation of probation. You're going to see Judge Lynch on January 22nd.
Your Honor, may I ask, on the count 1, is that a misdemeanor
It's,
or charged as a?
it's battery on someone over the age of 65 is a third-degree felony.
Okay. Is there any way that we could bring that down to 1,500?
She can address that with Judge Lynch on January 22nd when she sees him. At this point, based upon the allegations and the probable cause affidavit, I believe $2,500 is reasonable. I'm also going to order no victim contact if she does bond out. Okay. Siobhan Marie Loves. Okay.
Siobhan, Your Honor, did you ask for Siobhan Love?
Yes, Loves. Is it a medical
It's
reset?
a medical reset.
North Broward, Your Honor.
She's a medical researcher.
She's a medical reset? Okay, thank you. All right. George Perella Gonzalez.
Main jail.
Your Honor, he needs a translator.
Okay, okay, wonderful. Good morning. Please raise your right hand. Do you swear to translate from Spanish to English to Spanish to the best of your abilities?
I do. For the record, Moises Hernandez.
Okay. All right.
Bien.
All right,
Bien,
Mr.
señor.
Perella Gonzalez.
González.
You have an out-of-state
Usted
hold
tiene
for
una
Park
orden de
County,
retención de fuera del
Nevada.
estado
It is
del
a,
condado de Nevada.
looks like a no bond hold.
Es
Your
una
Honor, we can't
retención sin
understand
fianza.
anything. I guess when the translations are going at the same time, you can't hear both. So
Okay.
if we could do it one thing at a time.
Okay, Mr. Perella Gonzalez,
Señor Pirela González,
you had an out-of-state hold
usted tiene una orden de retención de fuera del estado,
from Nevada,
del estado de Nevada,
which is no bond.
que no incluye fianza.
Okay, I'm going to maintain your no bond hold,
Voy a sostener la retención de sin fianza
and you will get a date to see the extradition judge.
y recibir una fecha para presentarse ante el juez de extradición.
Okay, thank you.
Gracias.
All right. MD Shalman Raju. Okay, Mr. Raju, you were arrested for domestic violence, battery, and obstruction by disguise. I do find probable cause for the arrest. I'm going to set a $2,500 bond on count 1 and a $500 bond on count 2 with the special condition that there be no victim contact if you do bond out.
Your Honor, Mr. Raju has been here in South Florida for 7 years. He's not employed. He doesn't have any family here. There's no bond is possible for him. If there's any way that we could do ROR with pretrial with a monitor, he would be open to that. He had lower back surgery recently. This is a first offense. You know, also, I can't tell on my docket if count 2 is a misdemeanor or a felony, nor can I tell on the count 1. So 2,500, there's no way he could afford, he can't even afford the 500. So it's essentially holding him on a no bond.
Okay, at this point, based upon the allegation of the probable cause affidavit, I believe those bonds are appropriate. Thank you.
Your Honor, if we could have an order put in for access to his phone and his property, so that way maybe he can try and call somebody for help.
Yes, absolutely.
Thank you.
Okay. Samuel Christensen? All right, good morning, Mr. Christensen. You've been arrested for a domestic violence battery, a disorderly conduct, and a resisting without violence. I find probable cause for your arrest. I'm going to set bond on count 1 at $2,500. Counts 2 and 3, I'm going to set at $100 each.
Your Honor, again, he's 21 years old. His whole family is here. If we could set it, even split the difference to 1,500, there's a possibility that he could get out. He's working hard. This is a first offense. He has actual injuries on his face, and, excuse me, all over his face and on his arms. We do need a photo order for those injuries, but if we could please even just bring it down to 1,500, and then the 100 and the 100 we can keep. So it's a possibility that he can eventually get out.
Okay, I'll reduce it to 1,500.
Thank you, Your Honor.
You're welcome. And no victim contact if he does bond out.
Thank you, Your Honor.
Okay. All right, Ignacio Escandon. Okay, good morning, ma'am. Okay, what is your name?
Melina.
Okay, are you here for Mr. Ignacio Escandon?
Yes, I am.
And would you like to address the court?
Yes, please.
Okay, please raise your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, please state your name, spell your last name for the record.
Melina O'Connell, Oconnell.
Okay, yes, Ms. O'Connell.
On the night that all this happened, it was a long day. I had been drinking all day, and it just escalated. But it's a one-time thing. He has never laid a finger on anyone. We have 5 kids in a house with responsible people. It's just one bad night, and I told the cops, and they still took him under domestic violence. But he would never, ever do something like that to me. He just doesn't deserve to be in there for this. All he does is try to make me happy, and he does everything that he can possibly do for me. It's just not fair that he's there. That is not who he is.
Okay. Thank you, Ms. O'Connell. All right, defense, state.
Your Honor, he's been 41 years, 41 years in South Florida. He's a parent, he has children, three children that I know of who are under the age of 21, 14, 13, 9 years old. He's a window salesman, he works hard every day. If he were to be let out, ideally ROR pretrial, so he can continue to provide for his family. If we can put it as low as possible, or ROR, Your Honor, this is a first offense. He can go to his brother's house until this is all fixed, and until I'm sorry, I didn't hear the name, but
Miss
until she
O'Connell.
can, until she can, waive prosecution and hopefully work with the state to figure out this.
Okay. Madam State? Okay, I'm gonna set bond at $500 and I'm gonna order no victim contact.
Thank you, Your Honor.
Thank you.
May I?
Yes, Ms. O'Connor.
How long is this no contact? Like, we have a whole, like, life together.
I understand. You can contact the state attorney's office and you can talk to them about it and to Mr. Escondone's defense attorney. But at this point, while the case is pending, I'm gonna order that there be no victim contact. Okay, Roland Lozier?
Your Honor, we need a Creole interpreter.
Okay, do we have a Creole interpreter? We don't.
Do they, can you communicate with them at all or no?
He can communicate, it's just I noticed that there was some,
The situation is, Judge, there's not gonna be a Creole interpreter today. We would have to reset it for tomorrow to get the Creole interpreter. I don't know if that's what we wanna do.
let me ask him if he wants to go forward. Hold on
Okay.
one second. He says he'll go without.
Okay, all right, Mr. Lozier, you've been charged with domestic violence battery. Based upon the probable cause affidavit, I do find probable cause. Ma'am, are you here for Mr. Lozier? Okay, raise your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth? Yes? Okay, put your hand down. Please state your name and spell your last name for the record. Okay, you need a Creole interpreter. Okay, all right. What's your name? Okay. It looks like there is someone here for Mr. Lozier, but she also needs a Creole interpreter.
What is her name?
Dennis?
It's the alleged victim.
It's the alleged victim in this particular case. Okay. I guess in that case, I'm gonna reset this to tomorrow.
I would ask for convenience bond to be set in the meantime.
Okay.
It's a bondable offense, but to reset it. if it
Okay.
doesn't bond out.
I will set a $500 bond with no victim contact in the meantime, and then I will reset this to tomorrow so we can get a Creole interpreter.
Thank you, Your Honor.
Thank you. Calvin Jones?
He's approaching, Your Honor.
All right, Mr. Jones, you've been charged with domestic violence battery based upon the probable cause affidavit. I do find probable cause for the arrest. Yes. I'm sorry, I can't hear you at all.
There have been 2 prior domestic violence incidences with the same victim.
Okay. Were you able to hear the state? She indicated that there, she
I haven't
indicated.
heard her most of this time.
Okay,
Sorry.
no, that's okay. She just indicated that there was 2 prior domestic violence instances with this same victim. Okay. Defense, is there anything you'd like to say before I set bond?
Your Honor, those 2 prior cases weren't convictions, they were dropped. Furthermore, he's 48 years old, he has a lot of things going on with him, including 3 heart attacks, rhabdomyolysis, which is a muscle disease. He's diabetic, has lung disease with breathing treatments. In fact, he has to go to get his breathing treatments later today. He's blind in one eye, and he has cuts on his back and on his lips. If there's any way that we could set this ideally so he can get out, because he needs to take care of his medical conditions, which are just a lot. There are a lot of them.
All right, I'm going to set bond at $2,500 with a special condition that there be no victim contact if he does bond out.
Your Honor, there's no way that he would be able to bring, to pay that. if we could at least bring it down to 1,500, so there's a possibility that he could get out. You know, I guess my major concern at this point is all of these ongoing health conditions, especially as they relate to the diabetes and the lung treatment specifically that he needs. It's very concerning, and I would worry that I would worry that these things would get worse in here.
Okay. I think based upon the allegations and the fact that this was not the first allegation, I believe that $2,500 is appropriate. However, I am concerned about his medical condition. So I'm happy to sign an order to make sure that he's evaluated by a physician in custody and that he's receiving any and all treatment that he needs to make sure that
That's
they're
fine.
taking care of his health concerns.
Thank you.
Okay. All right. Benjamin Schler.
He's approaching, Your Honor.
All right, Mr. Schler, you've been charged with domestic violence, misdemeanor battery. Based upon the probable cause affidavit, I do find probable cause for the arrest. Defense, go ahead.
Okay. Sorry, I can't ever hear the state. I'm not sure if they're talking into the microphone, so that's the problem.
They haven't said anything. That's why you
Okay.
can't hear them.
Okay, Your Honor, Mr. Schler is a welder. He goes to work every day. This is his first offense. He's been here for 1.5 years. He's trying to, set up his life here in South Florida. He's working really hard. He's very young. If we could please set the bond at $1,000 so he can get back to work and so he doesn't lose everything that he's created here.
Your Honor, I don't see any Florida priors, but I was wondering if pretrial could check if there's any out of state.
Okay. Does he have any out-of-state priors? No? Oh, I'm sorry. I can't hear the feedback from the back. Okay, all right, I'm gonna set bond at $1,000, special condition, no victim contact if he bonds out.
Thank you, Your Honor.
All right, Joe Gibson. All right, Mr. Gibson, you've been charged with misdemeanor battery, domestic violence. Based upon the probable cause affidavit, I do find probable cause for the arrest.
This is not the first allegation of domestic violence, different victims, but this would be the third arrest for a domestic violence incident.
Okay. Defense, did you hear the state?
That's a third arrest, but it's not a
Correct.
conviction, correct?
That's correct.
Okay, all right, based upon the allegations in the probable cause affidavit as well as the previous arrest, I'm gonna set bond at $2,500 with a special condition that there be no contact with the victim if he is, to bond out.
Your Honor, if we could please bring that down. He's been here for 26 years. He works with a temp agency, working daily to make money and make ends meet. He does have family here, in South Florida and Boynton Beach. If we could please bring it down to 1,500, at least, his cousins and his family might be able to piece together some money to get him out. Otherwise, it'd be basically holding him on no bond, as when you're a day laborer, there's no way to make those ends meet. And his family wouldn't be able to afford $2,500.
Okay, I believe that $2,500 is appropriate given the nature of the offense and, the previous arrests. All right, John Paul Fike. All right, Mr. Fike, you've been charged with domestic violence battery based upon the nature of the probable cause affidavit. I do find probable cause for the arrest. State, does he have any priors?
Yes, Your Honor, he had a Palm Beach 2005 domestic violence with his wife at that time.
Okay. All right, defense, were you able to hear the state?
I heard 5 domestic violence. I didn't hear if they were arrests or convictions.
It was a 2005 arrest for domestic violence with his wife at that time.
Oh, in 2005?
Yes.
Okay. Your Honor, it sounds like there was no conviction, so that would mean that these are just allegations. That was over 15 years ago. Mr. Fike is 49 years old. He works at Century Records Reconditioning. 54 years old, I'm sorry. He's been in South Florida for 49 years. He works at Century Motors reconditioning cars. He has 4 children, one of them 14 years old. He has a lot of difficulty hearing. He has mental health concerns as well. So if we could please place the bond at $1,000. Well, I also understand that his wife may be dropping the charges.
Okay, I'll set bond at $1,000, no contact with the victim if he is to bond out.
Thank you.
All right. Paroled Andre Pierre. All right, Mr. Pierre, you've been arrested for domestic violence battery based upon the probable cause affidavit. I do find probable cause for the arrest. State, does he have any priors?
I don't see any priors, just traffic criminal.
Okay. All right, I'm gonna set bond at $500 with a special condition that there be no victim contact if he is to bond out.
Your Honor, I didn't hear. Did they say that he had priors?
No.
Okay. Your Honor, he actually called the police himself and ended up getting arrested. He works for Broward School Board. He's a social worker. He's 31. He's been in South Florida for 31 years. He's not trying to flee. He's not trying to do anything. He's assured me he will show up. If we could please ROR him and put him on pretrial release, he's very much willing to come in twice a week, do in-person pretrial.
All right, I'll put him on standard, I'll ROR him to standard pretrial. He has to call in twice a week.
Thank you. You got ROR,
And
you're gonna call him.
special condition that he have no contact with the victim.
Yes, Your Honor, thank you.
Gary Shane Johnson.
Howard.
Medical research, John.
Okay, medical research. All right. Willie Abram Coleman.
Your Honor, I'm gonna ask if I could please have a 10-minute break. I haven't been able to get to these individuals. I did my best. I was here at 40 in the morning, but I still have to see the rest of the people. So if I could just have 10 minutes.
Okay,
Thank you.
okay. Sure, if you just tell me which ones they are. Yeah, great idea. Right. All right. Gary Johnson, okay, this was the medical reset? Okay, all right. All right, Mr. Johnson, good morning. You were arrested for domestic violence, battery, and a resisting without violence. I do find probable cause for the arrest. Defense?
Judge, from what I can see, the only Florida priors are traffic criminal, so he has no criminal priors in the state of Florida. He's doing catering jobs right now. From my understanding, he can stay with a friend in Davie in the short term. I'm asking for him to be ROR to pretrial with a GPS open schedule.
Okay. All right, I will ROR you to standard pretrial with a GPS monitor, special condition that there be no contact with the victim, and at this point, no return to the incident location.
There's one in North Broward, about 3 down, would be Eric Zuckerman.
All right. Mr. Zuckerman, you've been arrested for battery on a person 65 years of age or older. All right. I do find probable cause for the arrest. State, does Mr. Zuckerman have any priors?
Did have a prior domestic violence incident, Your Honor, the state would be requesting a $3,000 bond with some form of pretrial with the special condition no alcohol or intoxicants and random testing and no victim contact.
Domestic violence was dropped, correct? Yeah, so it was just an arrest. Speaking to Mr. Zuckerman this morning, he's lived in South Florida his whole life. He has all his family down here. I understand in the short term, the case is going to be pending, but I do just want to point out in the probable cause affidavit, the alleged victim did state to the officer his plan is to decline the charges. Mr. Zuckerman did say he can stay with friends. He currently works at a battery repair company. He goes to Broward College currently. I'm asking for be ROR to pretrial, GPS open schedule.
All right, I'm going to set a bond at $1,500. If he bonds out with standard pretrial, and I'm going to order that there be no victim contact and that he have a drug eval and any and all follow-up treatment. All right, who do we have next?
Next,
Yes, please.
is this Mr. Vaughn who's before us right now? Actually, Mr. Vaughn, if we could put Mr. Vaughn on recall, the city attorney is going to come handle this case. She called me. She's not here yet.
Okay.
So if we could put Mr. Vaughn.
All right, Mr. Vaughn, we'll be right with you when the city attorney gets here, okay? So just have a seat for a moment.
So the next one up is going to be Joseph Malinowski. He's going to be a few pages down. But it's Malinowski, Malinowski.
Malinowski, got it. All right. All right, Mr. Malinowski, you have 4 capiases for traffic violations. And it looks like you have a $500 bond on each of those. You are set to see your division judge on January 22nd, so I'm going to maintain those bonds, and you can see your judge at that point.
Judge, Mr. Malinowski did request if it's possible for him to resolve this to an adjudication time served today. I explained to him there are potential ramifications here given the charges, but he wants to go forward if he could resolve it today.
All right, State, is there an offer to resolve Mr. Malinowski's cases today?
Looks like the prosecutor who's assigned to the case has an offer in there indicating he may be eligible for our diversion program to get a valid license, so I don't know if he's eligible to do that.
He's not, but he's okay with the ramifications.
Okay.
He understands, so can he get time served adjudication?
All right. All right, Mr. Malinowski, raise your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, put your hand down. Please state your name, spell your last name for the record.
Joseph John Malinowski.
All right.
I live in Mary.
No, go ahead.
Malinowski.
All right,
Miss. Feedback, I'm sorry.
No, that's okay. Mr. Malinowski, it's my understanding that you'd like to resolve your cases today. Is that correct?
Yes, ma'am.
Are you currently under the influence of any alcohol, drugs, or prescription medication?
No, ma'am.
Do you suffer from any physical or mental illness?
Left leg amputee, but nothing that can affect my decision.
Okay, all right. Mr. Malinowski, you have 4 charges pending before the court. They're all traffic criminal. It's operating without a valid license, failure to register a vehicle, operating without a valid license, and an unlawful license tag or sticker attached. If you wanted to resolve your case today, I would adjudicate you guilty on all 4 counts and give you credit for time served. Is that what you'd like to do?
Yes, ma'am.
Okay, you understand, sir, that you have the right to go to trial, and at trial, the state would have to prove these allegations against you beyond a reasonable doubt.
Yes, ma'am.
Okay, and other than what I've just told you, has anyone made you any other promises or guarantees today?
No, ma'am.
Is anyone threatening or coercing you into entering into this plea?
No, ma'am.
And are you doing this because you believe it's in your best interest?
Yes, ma'am.
All right, Mr. Malinowski, in case number 19-27919, TC 10A, to 1 count of operating without a valid license, 1 count of failure to register a vehicle, 1 count of operating without a valid license, and 1 count of unlawful license tag or sticker attached. How do you wish to plead?
Guilty.
All right, I'm going to accept your plea of guilty. I find the defendant to be alert and intelligent. He understands the nature of the charges and the consequences of entering into the plea today. So in case number 19-27919, TC 10A, and case number 19-27798, TC 10A, I'm going to adjudicate you guilty and give you credit for time served. Good luck to you, sir.
Thank you, Your Honor.
All right.
Judge, about 18 packets down on page 23 for those who have a docket. Christopher Hague, Hage.
All right. All right. Mr. Haig, good morning,
Yes, ma'am.
sir. You've been
Good morning.
charged with 1 count of aggravated assault with a deadly weapon without intent to kill, 1 count of misdemeanor battery, 1 count of stalking following a harassment, cyber stalking another, and 1 count of possession of cocaine. State.
He has previous cases that were dropped that deal with battery and stalking. I didn't have an opportunity to check to see who the victim was in those cases. The state would be recommending a $3,000 bond with level 2 pretrial with a GPS and no contact with the victim for count 1. Count 2, the $1,000 bond is fine. For count 3, a $1,000 bond with the same pretrial conditions as count 1 with a GPS monitor and no victim contact, and the convenience bond on count 4 is fine.
Mr. Haig this morning. He's lived in South Florida his whole life. He has all his family down here. He works at Rick Case. I have no objection to the monetary value. I would just ask to do it standard pretrial instead of level 2. If Your Honor is going to do it with the GPS, I would just ask for an open schedule.
Okay. All right, Mr. Haig, I'm going to set a $3,000 bond on count 1. I'm going to maintain the $1,000 bond on count 2. Count 3 will be a $1,000 bond. Count 4, I'm going to maintain the $1,000 bond. I'm going to put you on pretrial with an open schedule with a GPS monitor. And you are to have no contact with the victim, and you're not to come within 500 feet of the victim's home. Do you understand, Mr. Haig?
Yes, ma'am.
All right. Okay.
I could tell Your Honor, the last 3 on the docket, Rodney Rodriguez, Michael Cantanilla, and Michael Cooper are all going to be medical resets.
Okay, so Rodney Rodriguez, Michael Cantanilla, and Michael Cooper, right?
Yep.
Okay.
And then the one individual we put on, we'll come back to Mr. Vaughn in a second, but we have the city attorney here.
Okay, great.
So everyone else is at main judge.
Honor.
Thank you. On Mr. Vaughn, yes. Hey, good morning. All right, Mr. Vaughn, you have a capias for a possession of paraphernalia.
That's correct, Judge.
Okay,
Davika Carr on his behalf asking to be appointed.
okay, that'll be granted.
Thank you, Your Honor. If Mr. Vaughn is looking to resolve I'd be asking if Your Honor would give him time served.
All right, Mr. Vaughn, the offer to resolve your case today is an adjudication credit for time served. Is that what you'd like to do?
Yes, ma'am.
All right, please raise your right hand. Okay, do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, put your hand down. Please state your name, spell your last name for the record.
Jordan Vaughn, V as in Victor, AUGHN.
All right, Mr. Vaughn, it is my understanding you'd like to resolve your case today. Is that correct?
Yes, ma'am.
Are you currently under the influence of any alcohol, drugs, or prescription medication?
No, ma'am.
Do you suffer from any physical or mental illness?
No, ma'am.
Okay, sir, you are charged in case number 19-11134, MO 10A, with possession of paraphernalia. If you'd like to resolve your case today, the offer is an adjudication and credit for time served. Is that what you'd like to do?
Yes, ma'am.
Okay, is anyone threatening or coercing you into entering into this plea?
No, ma'am.
All right, and you understand that if you wanted to go to trial, you can go to trial and the city would have to prove these allegations against you.
Yes, I do.
Okay, but you'd like to give up that right and enter into this plea today?
Yes, ma'am.
All right. In case number 19-11134, MO 10A, to one count of possession of paraphernalia, how would you like to plead?
No contest.
No contest.
Okay, I'm going to accept your plea of no contest. I find the defendant to be alert and intelligent. He understands the nature of the charges and the consequences of entering into the plea today. Therefore, on case number 19-11134, MO 10A, on one count of possession of paraphernalia, going to adjudicate you guilty and give you credit for time served. Good luck, sir.
Thank you.
Have a good day, Jordan.
All right, let's go check back in with the main jail. All right.
Did you want me to call the ones you had or?
Oh, do you have any other ones?
I do, Your Honor, but.
Oh,
I
you
can
do? Okay,
place
so let's
them
do
on
those.
hold, I think.
All right, are you, go ahead.
Jason Morris on page 15.
all right. Do you know where he is? Is he in
Is that,
Main
is that main?
main jail?
Yes.
All right, Jason Morris?
Your Honor?
All right, Mr. Morris, you've been charged with one count of street solicitation. What's the offer from the city to resolve the case?
Your Honor, I'm asking to be appointed on his behalf, and we're just looking for time served.
All right, that's granted. Mr. Morris, if you want to resolve your case today, the city is offering you an adjudication credit for time served.
Okay.
Is that what you'd like to do?
Yes, Your Honor.
All right, raise your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, put your hand down. Please state your name, spell your last name for the record.
Jason Morris, Morris.
Okay, Mr. Morris, are you currently under the influence of any alcohol, drugs, or prescription medication?
No, ma'am.
Do you suffer from any physical or mental illness?
No, ma'am.
All right, Mr. Morris, you've been charged with one count of street solicitation. If you wanted to resolve your case today, the offer from the city is an adjudication and credit for time served. Is that what you'd like to do today?
Yes, ma'am.
Okay, you understand you have the right to plead not guilty and go to trial, and at trial, the city would have to prove these allegations against you.
Yes, ma'am.
Okay, but you enter into this plea today, you're gonna give up that right, you understand?
Yes, ma'am.
Okay, is anyone threatening or coercing you into doing this?
No, ma'am.
And are you doing this because you believe it's in your best interest?
Yes, ma'am.
All right, Mr. Morris, how would you like to plead to one count of street solicitation?
No contest.
Yeah, no contest.
All right, I'm gonna
No
accept,
contest.
okay, I'm gonna accept your plea of no contest. I find the defendant to be alert and intelligent. He understands the nature of the charges and the consequences of entering into the plea today. Therefore, on one count of street solicitation, I'm going to adjudicate you guilty and give you credit for time served. Good luck, sir.
Thank you, Your Honor.
Jason. The next one, Your Honor, is Melvin Black, also on page 15, also at main jail.
Okay?
Should be approaching.
Main jail, Your Honor.
Thank you, Deputy.
All right, good morning, Mr. Black. You are charged with one count of a municipal ordinance violation, which is public consumption of alcohol.
Yes, Your Honor, he's looking to resolve to time served today.
Okay.
Your Honor's
All right, Mr. Black, the city is indicating that if you wanted to resolve your case today, the offer is an adjudication and credit for time served. Is that what you'd like to do?
Yes.
All right, please raise your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, put your hand down. Please state your name, spell your last name for the record.
Melvin Gary Black, B-L-A-C-K.
All right, Mr. Black, are you currently under the influence of any alcohol, drugs, or prescription medication?
No,
All right, do you suffer from any physical or mental illness?
no.
All right, sir, you're charged in with in case number 191680, MO 30A, with public consumption of alcohol. The offer from the city, if you wanted to resolve your case today, is an adjudication and credit for time served. Is that what you'd like to do?
Yes, ma'am.
Okay, you understand you have the right to plead not guilty and go to trial. At trial, the city would have to prove these allegations against you.
Yes, ma'am.
Okay, is anyone threatening or coercing you into entering into this plea?
No, ma'am.
Are you doing this because you believe it's in your best interest?
Yes.
Okay, Mr. Black, in case number 191680, MO 38, to one count of public consumption of alcohol, how do you wish to plead?
No contest.
I'm going to accept your plea of no contest. I find the defendant to be alert and intelligent. He understands the nature of the charges and the consequences of entering into the plea today. Therefore, in case number 191680, MO 30A, I'm going to adjudicate you guilty and give you credit for time served. Good luck, sir.
Thank
Have a
you.
good day, Mr. Black. And Your Honor, I have one more, Mr. Miller, Willie Miller on page 17.
Willie Miller.
Hey, Willie.
All right, good morning, Mr. Miller. You're charged with one count of, you actually had a capias for an alcohol beverage violation from the city. All right,
Yeah.
Yes, Your Honor. Mr. Miller, would you like to resolve today?
Yes.
Okay. If Your Honor would be inclined to giving him time served.
all right. Mr. Miller, the offer from the city is time served. Is that what you'd like to do?
Yes.
All right, raise your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, put your hand down. Please state your name, spell your last name for the record.
My first name is Willie. My last name is Miller. M-I-L-E-R.
All right, Mr. Miller, are you currently under the influence of any alcohol, drugs, or prescription medication?
No.
Do you suffer from any physical or mental illness?
No.
How old are you, sir?
45.
And how far did you get in school?
I graduated.
Okay. All right, Mr. Miller, you're charged with one count of an alcohol or beverage violation from the city. The city indicated if you wanted to resolve your case today, they would give you an adjudication and credit for time served. Is that what you'd like to do?
Yes.
Okay, Mr. Miller, you understand you have the right to plead not guilty and go to trial. At trial, the city would have to prove these allegations against you.
Right.
Okay, but you enter into this plea today, you're gonna give up that right, you understand?
Right.
Okay, is anyone threatening or coercing you into entering into this plea?
No.
You doing this because you believe it's in your best interest?
Yes.
All right, Mr. Miller, in case number 19-10156, MO 10A, to one count of alcohol or beverage violation, how do you wish to plead?
No
Not
contest.
guilty.
No
No
contest.
contact.
Okay, I'm gonna accept your plea of no contest. I find the defendant to be alert and intelligent. He understands the nature of the charges and the consequences of entering into the plea today. So I'm going to adjudicate you and give you credit for time served, all right? Good luck to you, sir.
Have a good day, Willie. Thank you, Judge.
Thank you. All right. Is your co-counsel ready? All right.
The problem is, Judge, you can see how they got the camera.
Oh, there she is.
Thank you for, Your Honor, for that time. I
No
appreciate
problem. Do you need more time or are you ready to proceed?
it. We can proceed.
Okay. All right, so the next person we have is Willie Coleman.
Yes, Your Honor. Willie Coleman's approaching.
Okay, Mr. Coleman, you're charged with one count of domestic violence battery and one count of obstructing or depriving by means to protect or communicate. Based upon the nature of the probable cause affidavit, I do find probable cause for your arrest. State.
He has one prior, Your Honor, from Duval County for a charge that's called fighting.
Okay.
Okay. Your Honor, Mr. Coleman has been in South Florida for 26 years. He has his mother here. He has a 3-year-old child. He has injuries, and we would need an order for photos of those injuries. We're asking for $1,000 to $1,500 bail. That's what he could afford. Otherwise, anything above that would be essentially a no bond hold at this point, because while he has his mother here, he has she's on a fixed income, and there's really no ability to help him at that point. He would be going home to his mom's house, and I don't know what, is it schlepping? What is it? Is the charge?
Domestic violence battery, and then
No, I'm sorry, Your Honor, the prior.
The
I
prior
didn't
was,
know the
it was
particular-
labeled as fighting.
fighting.
Oh, okay.
Okay, all right, based upon the allegations in the probable cause affidavit, I'm going to set a bond at, on count one of $5,000 and on count two of $100. Special condition that there be no contact with the victim if he does bond out and no return to the incident location.
Again, Your Honor, there's no way he could afford that. That would be essentially holding him on a no bond hold. And also, we're asking if we could please have the order for photos.
Yes, you can have the order for photos.
Okay.
Okay,
Thank
all right. Wilmington Jeffers Toussaint.
Yes, Your Honor, we're here.
Okay. All right, Mr. Toussaint, you've been charged with domestic battery by strangulation, a misdemeanor domestic violence battery, and then you have a capias from a traffic criminal court. Based upon the probable cause affidavit, I do find probable cause for the arrest.
Yes, Your Honor, there is a history of domestic violence cases that have been presented but not filed, including battery on a aggravated battery on a pregnant female, tampering with a victim, felony batteries dating back to 2015. There were instances, multiple instances in 2019. Didn't have an opportunity to see if it was the same victim. Based off of the nature of the allegations and what has been presented in the probable cause affidavit, the state would be recommending a $5,000 bond with level 2 pretrial and no victim contact.
Your Honor, the state has just said that those prior allegations were never filed upon, which means that we shouldn't be considering those at this time. Your Honor, if we could please bring down those bonds to $2,500. That seems like a reasonable and fair amount. He's 23 years old. He's a baby. He's a mechanic. He's got a child who's 6 months old. Again, to bring up not filed cases, it just seems prejudicial.
Okay, based upon the allegations in the probable cause affidavit, I'm going to set bond on count one, in the amount of $5,000, count two, $500. I'm keeping the $100 bond. I'm also, if he does bond out, I'm gonna put him on on level 2 pretrial with a GPS ankle monitor with a special condition that there be no contact with the victim and no return to the incident location.
Thank you.
Sorry, Your Honor, what was count 2?
Count two is $500, count one has the $100 bond still. Okay, Javier Antonio Laguna.
Yes, Your Honor, he's coming.
Okay, all right, Mr. Laguna, you've been charged with domestic violence, battery, and tampering in misdemeanor proceeding. I do find probable cause, based upon the allegations of the probable cause affidavit. State, are there priors?
No, Your Honor.
Okay, all right,
Your Honor, he's been here for 16 years. He has a job right now, and he's holding it down at Chick-fil-A. He's got 3 children. One's 8, one's 13, and one's 18, just about to start his own adult life. This is a first offense. At most, Mr. Laguna can pay up to the $1,500, and he really wants to get back to his children. If there's any way that we could please, at most, put this bond at $1,500.
all right, I'm gonna set bond on count one at $500 and count two at $500. Special condition that there be no contact with the victim and no return to the incident location.
Okay, thank you, Your Honor. If we could have an order for access to his phone as well.
Yes, that's fine.
Property. Thank you.
Okay, all right, James Doyle,
Medical reset.
okay. Courtney Hay,
Yes, Your Honor, he's present and approaching.
Okay, Mr. Hay, you've been arrested for resisting an officer without violence and trespass. Based upon the allegations in the probable cause affidavit, I do find probable cause for the offense. All right, you already have a $100 bond on count one. Defense? Are you, okay.
I couldn't hear that, Your Honor.
No, that's okay. State, does he have priors?
He does, Your Honor. He has an attempted robbery from 2002 with a deadly weapon and a 07 grand theft. I was
Okay.
gonna recommend the convenience bonds.
All right, so I'm gonna set a $100 bond on count two, and then I'll maintain the $100 bond on count one.
Your Honor, Mr. Hay has told me that he would like to ask open plea to the court, to resolve these two charges.
State, is there an offer from the state to resolve?
I'll offer an adjudication court cost, Your Honor.
Okay, the offer from the state is an adjudication and court costs. Does Mr. Hay like to, resolve his case?
Is there any way that we could do adjudication time served?
Yes, adjudication credit for time served. Right,
Thank you.
yes. Okay, all right, Mr. Hay, raise your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, put your hand down. Please state your name, spell your last name for the record.
Courtney Hay, Hay, Haye.
All right, Mr. Hay, it's my understanding you'd like to resolve your cases today, is that correct?
Yes, ma'am.
Are you currently under the influence of any alcohol, drugs, or prescription medication?
No, ma'am.
Do you suffer from any physical or mental illness?
No, ma'am.
How old are you, sir?
I'm 38.
All right, Mr. Hay, you've been charged in count one with resisting an officer without violence and count two, misdemeanor trespass. The offer from the state, if you wanted to resolve your cases today, is an adjudication and credit for time served. Is that your understanding?
Yes, ma'am.
Okay, other than that, has anyone made you any other promises or guarantees?
No, ma'am.
Has anyone threatened or coerced you into entering into this plea?
No, ma'am.
Are you doing this because you believe it's in your best interest?
Yes, ma'am.
Okay, Mr. Hay, you understand you have the right to plead not guilty and go to trial. At trial, the state would have to prove these allegations against you beyond a reasonable doubt. You understand?
Yes, ma'am.
Okay, all right. On one count of resisting without violence and one count of trespass, how do you wish to plead?
No contest.
Okay, I'm going to accept your plea of no contest. I find the defendant to be alert and intelligent. He understands the nature of the charges and the consequences of entering into the plea today. Therefore, on count one, resisting or obstructing without violence, and count two, trespass of an unoccupied structure, I'm going to adjudicate you guilty, give you credit for time served. Good luck, Mr. Hay.
Thank you.
All right, John Figueroa.
He's present and approaching.
All right, Mr. Figueroa, you have 4 capiases from your misdemeanor case. They already have bonds of $100, $250, $250, and $100. I'm going to maintain those bonds, and it looks like you're set to see your judge on January 22nd.
Your Honor, Mr. Figueroa is homeless. He has a brother here in South Florida. He also has a daughter, and he really wants to see her. He actually had an appointment scheduled to see her, which is very difficult when you are homeless. We're asking for ROR with standard pretrial. He's willing to do one-on-one in person. These are not violent charges. The KPS, because he's homeless, these are not willing or it was not a willing, he wasn't given notice. So if we could please put him on ROR and also have him do pretrial release with in-person.
Okay, at this point, I'm not going to change the capias amounts. He can speak to his division judge about that on January 22nd if he doesn't bond out before that. All right, on Hawithia King.
Your Honor, if we could please go back to Mr. Figueroa, then he's let me know that he would like to resolve these cases.
Okay,
We could open plea to the court, and we would be looking for time served.
State, is there an offer on these cases?
If I can just take a moment, I think one of them is a reckless.
Yes.
I want to see what's involved with it.
Okay.
Looks like the offer in court case number 1902546 TC10A is for the reckless and adjudication court costs, 3 months of probation with the special condition of an 8-hour driving school, that for the driving while license suspendence count and adjudication court costs. Let me see the cannabis. For the cannabis, the state's offer was a withhold court cost, and for his driving other offenses, it's an adjudication court cost.
Okay, did you hear that? It looks like it's a, I guess, a withhold and court cost on the possession of cannabis, on the driving while license suspended and operating without a valid driver's license, it was an adjudication and court cost. And then on the reckless driving, it's an adjudication, 3 months probation with a special condition of the 8-hour driving course?
Yes,
Is that
Your
what it
Honor.
said? Okay.
Okay, I guess we're gonna go back to, the possible bonds. Your Honor, again, he's homeless. He didn't, these capiases, they weren't willful. If we could please,
Okay, at
have
this
him
point,
just
I'm not changing the capias amounts. He can see his judge on January 22nd and discuss whether or not he willfully failed to appear. All right?
Okay, thank you.
All right, Hawithia King. All right, Mr. King, you have a capias on your traffic case. It looks like you're set to see your judge on January 27th.
Your Honor, he would like to resolve today.
Okay.
We're looking for a time served.
All right, State, what's the offer on Mr. King's case? It's an operating without a valid driver's license.
Adjudication court cost.
Okay, all right, Mr. King, the state said it's an adjudication credit for time served, okay? All right,
you.
raise your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay, put your hand down. Please state your name, spell your last name for the record.
Hawaii King, King.
All right, Mr. King, are you currently under the influence of any alcohol, drugs, or prescription medication?
No, ma'am.
Okay, do you suffer from any physical or mental illness?
No, ma'am.
All right, sir, you have one count of operating without a valid driver's license in case number 13-18769 TC10A. The offer from the state to resolve your case is an adjudication credit and time served. Is that your understanding?
Yes.
Okay, you understand you have the right to plead not guilty and go to trial. At trial, the state would have to prove these allegations against you.
Yes.
Okay, you enter into this plea, you're going to give up that right. You understand?
Yes.
That's what you'd like to do?
Yes.
Okay, anybody forcing or coercing you into doing this?
No.
All right. Mr. King, in case number 13-18769 TC10A to one count of operating without a valid driver's license, how do you wish to plead?
No contest.
No contest.
All right, I'm going to accept your plea of no contest. I find the defendant to be alert and intelligent. He understands the nature of the charges and the consequences of entering into the plea today. Therefore, to one count of operating without a valid driver's license, I'm going to adjudicate you guilty and give you credit for time served. Good luck, sir. All right. Joseph Batten.
All the way down. Yes, ma'am, Your Honor.
All right, Mr. Batten, you're charged with one count of trespass. You already have a $100 bond. I do find probable cause for your arrest. All right.
Your Honor, we're asking to resolve this case. We're looking for, a credit time served offer.
State.
That's fine, Your Honor.
Okay. All right. Mr. Batten, raise your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, put your hand down. Please state your name, spell your last name for the record.
Joseph Jerome Batten, last name B-A-T-T-E-N.
All right, Mr. Batten, are Are you currently under the influence of any alcohol, drugs, or prescription medication?
No, ma'am.
Do you suffer from any physical or mental illness?
No, ma'am.
Okay. You're charged with one count of trespass. The offer from the state to resolve your case is an adjudication and credit for time served. Is that what you'd like to do?
Yes, ma'am.
Anybody forcing or coercing you into doing that?
No, ma'am.
You understand you have the right to plead not guilty and go to trial. At trial, the state would have to prove these allegations against you.
Yes, ma'am.
All right, sir. To one count of trespass, how do you wish to plead?
No contest.
I'm going to accept your plea of no contest. I find the defendant to be alert and intelligent. He understands the nature of the charges and the consequences of entering into the plea today. Therefore, on one count of trespass, I'm going to adjudicate you guilty and give you credit for time served. Mr. Batten, you've been previously trespassed from this location. You cannot go back. If you keep going back, you're going to keep getting arrested, okay? So don't go back there.
All right.
All right. Have a nice day, sir. All right. Kent Allen Comax.
Yes, Your Honor, he's approaching.
Okay, Mr. Comax, you've been arrested for one count of DUI, one count of DUI U-Ball, one count of driving while license suspended, as well as several traffic infractions. You already have a bond on count 1 and count 2. I'm going to maintain those bonds, and I'm going to set the bond on count 3 at $500. Yes.
Your Honor, this is a,
Hold on one second. Yeah. Good morning.
Pretrial services. He's currently out of pretrial for case number 2000004 MU10A for DUI, count 1, count 2 DUI level 0.5, count 3 DUI property damage injury. We requested his pretrial to be revoked. He was placed on pretrial January 8th of this year.
Okay, at this point, based upon the probable cause that he has been arrested for DUI and he was out on pretrial on DUI, I'm going to revoke his pretrial and hold him no bond on his previous case in case number 2000304 MU10A.
Your Honor, if we could please bring down from 500, count 3 to 100. This is a driving with license suspended. This is the first offense. This is a nonviolent offense. If we could please bring that down. Also, Your Honor, he has injuries all over his body. If we could please have an order for photos on those.
You can have an order for photos. I believe that $500 is appropriate on count 3. Okay.
Also, Your Honor, if we could have an order for access to his phone.
Yes, that's fine.
Thank you.
No bond. Correct. All right. Scott Coy.
He's coming, Your Honor.
Okay.
Good morning, ma'am.
Good morning, Mr. Coy. You've been arrested for petty theft in the second degree and trespass. I do find probable cause for the arrest. You already have a bond on count 2 trespass, which is $100.
Your Honor, we're asking to open plea to the court. If we're looking for credit for time served.
State.
That's fine, Your Honor.
Okay. All right. The state said that they'd offer that. Okay. So, Mr. Coy, raise your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. Put your hand down. Please state your name. Spell your last name for the record.
Scott Aaron Coy, K-O-I.
All right, Mr. Coy, are you currently under the influence of any alcohol, drugs, or prescription medication?
No, ma'am.
Do you suffer from any physical or mental illness?
No, ma'am.
Okay, all right, sir, you're charged with one count of petty theft in the second degree and one count of trespass. The offer, if you wanted to resolve your case today, is an adjudication credit for time served and no return to that Publix. Is that what you'd like to do today?
Yes, ma'am.
Okay, is anyone threatening or coercing you into entering into this plea?
No, ma'am.
Are you doing this because you believe it's in your best interest?
Yes, ma'am.
All right, Mr. Coy, you understand you have the right to plead not guilty and go to trial. If you wanted to go to trial, the state would have to prove these allegations against you.
Yes, ma'am.
All right, Mr. Coy, on one count of petty theft in the second degree and one count of trespass, how do you wish to plead?
I say no contest. No contest?
I'm going to accept your plea of no contest. I find the defendant to be alert and intelligent. He understands the nature of the charges and the consequences of entering into the plea today. Therefore, on one count of petty theft in the second degree, on one count of trespass, I'm going to adjudicate you guilty and give you credit for time served. You cannot return to that public, sir, okay?
Yes, ma'am,
All right,
thank you.
good luck to you, sir. All right, Timothy Freeman? All right, Mr. Freeman, you've been arrested on one count of DUI, one count of failing to obey a police or fire department, and one count of refusal to submit to a DUI test. State.
Your Honor, the defendant does have a prior DUI that was changed to a reckless driving in 2019 out of Palm Beach. The state would be recommending, in addition to the convenience bond, standard pretrial with the condition of no alcohol, no intoxicants, and random testing.
Okay.
I'm sorry, I couldn't understand the full thing. Can you say that again?
Yes, I can. In 2019, Mr. Freeman had a DUI that was changed to a reckless driving out of West Palm Beach. So the state would be recommending, in addition to the convenience bond, standard pretrial release with the condition of no alcohol, no intoxicants, and random drug testing.
Okay. All right, so on count one, there's already a $500 bond. On count two, I'm gonna set a $100 bond, and on count three, I'm gonna set a $500 bond with a condition that if he bonds out, he'll be on standard pretrial. Special condition, no alcohol or intoxicants, random testing. Okay?
Your Honor, so it would be 500 on the refusal to submit? Is that
Yes.
what you're saying?
Yes, $500 on the refusal, $100 on the failure to obey the police officer. There's already a $500 on the DUI. Plus, if he bonds out, he'll be on standard pretrial with a special condition that there be no alcohol, no intoxicants, and random testing.
Okay.
All right.
Your Honor, we're gonna object to if the prior was, that reckless was considered as a DUI because it was changed to a reckless, which means that the state had a case for a reckless and not for a DUI. So just wanted to object to, bringing up something that never actually was.
Okay, your objection
second
is
of all-
noted.
I'm sorry, Your Honor, I didn't mean to interrupt.
No, that's
interrupt you.
okay. Was there anything else?
Yes, Your Honor, we're also gonna ask if you could please bring down count 3, refuse to submit to DUI test down to 100.
No, I believe $500 is appropriate.
Okay,
All
thank you.
right, Demetrius Wright.
He bonded, Your Honor.
Okay.
Your Honor, Mr. Shelton has decided to represent himself.
Okay. Mr. Shelton? All right, good morning, Mr. Shelton. You've been arrested for petty theft in the second degree and trespass. You already have a $100 bond on the petty theft. I do find probable cause for the arrest. All right, are you interested in resolving your case today, or I can set a bond on count 2 and then you can bond out if you can and go see your assigned judge?
I would like to resolve the case.
Okay, State, is there an offer for Mr. Shelton to resolve his case today?
Yes, Your Honor, adjudication and credit time served.
Okay, Mr. Shelton, the state indicated if you wanted to resolve your case today, they would be offering you an adjudication credit for time served. Is that what you'd like to do? Okay,
Yes, Your Honor. Raise
your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, please state your name, spell your last name for the record.
Robert Shelton, Shelton.
All right, Mr. Shelton, are you currently under the influence of any alcohol, drugs, or prescription medication?
No, Your Honor.
Do you suffer from any physical or mental illness?
No, Your Honor.
How old are you, sir?
52.
How far did you get in school?
I graduated from high school.
Okay, great. All right, Mr. Shelton, you're charged with one count of petty theft in the second degree and one count of trespass. The state is offering you an adjudication and credit for time served. Is that what you'd like to do?
Yes, Your Honor.
Okay, you understand you have the right to plead not guilty and go to trial, and if you went to trial, the state would have to prove these allegations against you.
Yes, Your Honor.
All right, but by entering into this plea, you're going to give up that right. You understand?
Yes, Your Honor.
That's what you'd like to do?
Yes.
Anyone threatening or coercing you into entering into this plea?
No.
You doing this because you believe it's in your best interest?
Yes, ma'am.
All right, Mr. Shelton, On one count of petty theft in the second degree and one count of trespass, how do you wish to plead?
No contest.
And accept your plea of no contest, I find the defendant to be alert and intelligent. He understands the nature of the charges and the consequences of entering into the plea. Therefore, on one count of petty theft in the second degree, one count of trespass, I'm going to adjudicate you guilty and give you credit for time served. Good luck to you, sir.
Thank you, Your Honor. Have a nice day.
You too, sir. Sean Jacobs?
Your Honor, he's present and approaching.
Okay, I do find probable cause for Mr. Jacobs' arrest for petty theft in the second degree.
Yes, Your Honor, he would like to resolve today. We're looking for a time serve offer.
State? Okay, thank you.
Sorry, I'm just checking the last line in the PC. I don't know if that indicates he's on probation. I'm just checking real quick.
Your Honor, he states that he's not on probation of any sort.
That's fine, Your Honor. That's taken off an adjudication credit time served.
Okay, all right, Mr. Jacobs, raise your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, put your hand down. Please state your name, spell your last name.
Sean Jacobs, Jacobs.
All right, Mr. Jacobs, are you currently under the influence of any alcohol, drugs, or prescription medication?
No, ma'am.
Okay, do you suffer from any physical or mental illness?
No, ma'am.
All right, Mr. Jacobs, you've been charged with one count of petty theft in the second degree. The offer to resolve the case today is an adjudication and credit for time served. Is that what you'd like to do?
Yes, ma'am.
Okay, anyone threatening or coercing you into entering into this plea?
No, ma'am.
You doing this because you believe it's in your best interest?
Yes, ma'am.
All right, Mr. Jacobs, you understand that you have the right to plead not guilty and go to trial. At trial, the state would have to prove these allegations against you.
Yes, ma'am.
All right, Mr. Jacobs, on one count of petty theft in the second degree, how do you wish to plead?
No contest.
I'm going to accept your plea of no contest. I find the defendant to be alert and intelligent. He understands the nature of the charges and the consequences of entering into the plea today. So therefore, on one count of petty theft in the second degree, I'm going to adjudicate you guilty and give you credit for time served. Good luck, sir.
Thank you.
All right. Austin Taylor. All right. Yes, you may. All right, we have somebody here for Mr. Taylor. What's your name, ma'am?
Michelle Taylor.
Okay, and do you want to speak on Mr. Taylor's behalf?
Yes, please.
Okay, please raise your right hand. Do you swear or affirm that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can put your hand down. Please state your name, spell your last name for the record.
Michelle Taylor, Taylor.
Okay, Ms. Taylor, what would you like to tell the court?
That's my son. I'm not sure exactly what happened. This is his first time in trouble. He has a home to come home to. He has a job to go back to. This is my first time dealing with this, so I'm just here to do whatever I can to get him out of this mess.
All right, thank you, Ms. Taylor. All right, Mr. Taylor, you've been charged with one count of aggravated assault with a deadly weapon. All right, based upon the allegations in the probable cause affidavit, I do find probable cause for the arrest. State, does Mr. Taylor have any priors?
He does not have any priors, Your Honor, but based off of the allegations, the state would be recommending a $3,000 bond plus standard pretrial and no victim contact.
It's better than what we're.
Okay. Defense, is there anything you'd like to add?
Your Honor, he's 24 years old. He's been here for 7 years. He works full-time. He works with the pool service. He clearly has support from home. If we could please bring that down to $2,000, that way we can ease the amount that he would have to pay. Again, pool service, well, he's gainfully employed is not high paying by any means. And I, seeing his mother there willing and able to support him as best she can, I think that it merits going to a discounted amount.
Okay, based upon the allegations in the probable cause affidavit, I am gonna set bond at $3,000 with a special condition that there be no contact with the victim and no return to that, McDonald's. Thank you. All right,
Thank you.
Jaqueen Bullard? Okay, Mr. Bullard, you've been arrested for possession of a weapon or ammo by a convicted felon, resisting an officer without violence, and you also have a violation of community control from Judge Fine. I do find probable cause for the arrest on count one. Based upon the allegations in the probable cause affidavit, I am going to set bond at $5,000. On count two, I'm going to set bond at $100. I'm going to maintain the no bond hold on the violation of community control. You are set to see Judge Fine on January 22nd at 8:45 to address your violation of community control.
Your Honor, we're gonna ask if it's possible to bring, for count one down to 3,000. Mr. Bullard is indigent, does not have as $500 that would be able to pay out along with the 100, and he's already set on a no bond hold because of the, violation. Can we please bring that down to 3,000?
I think based upon the allegations of the probable cause affidavit, as well as the amount of ammunition and firearms that were located, I believe $5,000 is a reasonable bond, given the circumstances. All right,
Thank you.
Eddie Mays. All right, Mr. Mays, you've been arrested for one count of driving while license suspended, third or subsequent offense. I do find probable cause for the arrest. Your bond is already set at $750.
Yes, Rob.
Don't say anything.
Boy, do what that say. Do what that do.
Hold on one second. Your Honor, is this charged as a felony or misdemeanor?
Right now, it's charged as a third-degree felony.
Okay.
All right,
Then we're
so
fine with this.
I'm maintaining the $750 bond. All right. Okay, Michael Slatter. Okay, Mr. Slatter, you've been charged with one count of burglary of an unoccupied dwelling and one count of petty theft in the second degree. All right, based upon the probable cause affidavit, I do find probable cause for the arrest. State, does Mr. Slatter have any priors?
He has traffic criminal, Your Honor, and that's all I'm seeing right now.
Okay. All right, I've had an opportunity to read the probable cause affidavit. It appears as though Mr. Slatter was inside of an unoccupied dwelling where I guess he was sleeping and charging his phone. Is that correct? Okay. All right, I'm gonna set bond on count one at $500, and I'm going to ROR him on count two, and then I'm gonna, special condition of standard pretrial, where he has to call in twice a week.
Your Honor, I don't see him taking anything. I don't see any, for the petty theft charge, I don't see any.
It looks as though he was, the allegations say that he was charging his devices, and the victim estimated the loss to be at about $5.
That's the petty theft?
State. I've ROR'd him on count 2.
Your Honor, it seems like the way that it's been presented is the theft would be the use of the electricity
Correct, with the
with
$5.
the $5.
Your Honor,
Well, I've ROR'd him on count 2.
I understand you've ROR'd him on count 2, but I have to make objections to the PC, and I object to that.
Okay, your objection is noted. I do find probable cause. I'm gonna ROR him on count 2, $500 on count 1. Special
Okay, Your Honor,
condition,
I'm sorry, again, I don't mean to interrupt you. Your Honor, he's homeless. He was seeking, refuge. I don't know exactly what happened, but he states that it was raining very hard. He's seeking refuge. He's homeless. There's no way that he can, pay even a 500. It's just absolutely impossible. Is there any way that we could put him on pretrial release and ROR him on both?
state.
Your Honor, he only has traffic criminal. If the court is inclined to do that, I just ask for no victim contact and no return to the
Okay,
location.
I'll ROR him on both counts in light of the allegations. I'll put him on standard pretrial on both counts. No return to the location and no contact with the victim.
Thank you. Okay.
All right. Renee Rodriguez. Okay, Mr. Rodriguez, you have a violation of parole that has a no bond hold from the Department of Corrections. I'm going to maintain your no bond parole hold. Okay. Thank you, sir. All right. Kenoli Gardner. All right, Mr. Gardner, you have you've been arrested for one traffic infraction, which is an unlawful speed. And then you have a violation of probation from Judge Coleman. There's a no bond hold on your violation of probation. You're set to see Judge Coleman on January 22nd at 8:30. I'm maintaining the no bond hold. You can see Judge Coleman on the 22nd. Thank you. All right, Lawrence Cherry. All right, Mr. Cherry, you have a violation of probation from Judge McCarthy. You are set to see her on January 22nd at 8:30. I do find probable cause. I'm going to maintain your no bond hold, and you can see Judge McCarthy on the 22nd. Thank you, sir. All right. Michael Allison O'Brien. All right, Mr. O'Brien, you've been arrested for one count of knowingly giving a false name or information to a law enforcement officer, failing to register a motor vehicle, driving while license suspended, and you have a no bond hold for a violation of probation from Judge Fine. You have a $100 bond on count 1. I will set the bonds on count 2 and 3 at $50 each. And I'm going to maintain the no bond hold on the violation of probation. You're set to see Judge Fine on January 22nd at 8:45. All right, thank you, sir. All right. Kenneth Hodge.
He's a medical reset, Your Honor.
Okay. Gladstone Fuller.
Yes, he's coming, Your Honor.
Okay, Mr. Fuller, you've been arrested for criminal mischief of a church or a synagogue in count 1, criminal mischief in count 2, resisting an officer without violence on count 3. Counts 4 and 5 are misdemeanor capiases. You also have count 6, aggravated battery with a deadly weapon. Count 7 and 8 are battery on a law enforcement officer or firefighter. Okay, you also have a status set on January 22nd in front of who?
Your Honor, on the capiases, counts 4 and 5, he hasn't been receiving his mail, so he wasn't provided notice with, the fact that he was being called to court. If we could lower those to $100, please.
State, what's your recommendation with regard to bond on the aggravated battery with a deadly weapon as well as the battery on a law enforcement officer counts?
Your Honor, for count 6, the state would be recommending a $5,000 bond. Count 7, a $2,000 bond. And no victim contact.
Your Honor, on count 7, what was the amount?
On count 7, I'm sorry, State, you said it was.
I think I said $2,000.
$2,000.
Okay.
Okay, based upon the allegations in the probable cause affidavit, I do find probable cause for the arrest. I'm going to maintain the $1,000 bond on count 1 and the $100 bond on count 2. On count 3, I'm going to set a $500 bond. I'm going to maintain the $250 bonds on the capiases. On their aggravated battery with a deadly weapon, I'm going to set a $5,000 bond. And on counts 7, I'm going to set a $1,000 bond. And on count 8, I'm going to set a $1,000 bond. I'm sorry? Oh, I don't see 9 and 10. All right, 9 and, possession of, okay, it looks like he also is being charged in count 9 on possession of a weapon or ammo by a convicted felon, in count 2 obstructing or depriving by means of protection. So on count 9, I'm gonna set a $1,000 bond, and on count 10, I'm gonna set a $1,000 bond.
Your Honor, if we could please come down on count, again, on count 7, if we could please come down to $1,000, as well as on count 3, if we could come down to $100, as it seems that they're charging for both resist and obstruct with violence, and then they're later charging him again on these same counts, but now as a battery as well.
Okay, I think based upon the allegations in this particular offense and the seriousness of them, I believe that those bonds are appropriate, so I'm going to maintain them as I previously indicated. All right.
Your Honor, also, he's 62 years old. He's been in South Florida for 30 years. If we could, he has some issues with his teeth. He's also got very serious mental health issues. Could we please have an order for a doctor to come and check on him?
Yes, absolutely. I'll order an evaluation.
Thank you.
All right, you're welcome. Okay, Adam Breslow. All right, Mr. Breslow, you've been arrested for 1 count of possession of fentanyl, 1 count of drug paraphernalia, another count of drug paraphernalia, 1 count of neglect of a child without great bodily injury, 1 count of driving while license suspended, and then a traffic infraction for failure to drive in a single lane. Based upon the probable cause affidavit, I do find probable cause for the arrest. It looks like you already have on count 1 a $1,000 bond, and counts 2 and 3 you have a $100 bond. State, what's your recommendation on count 4?
I'd recommend a $1,000 bond, Your Honor.
Sorry, Your Honor.
No, that's okay.
If we could bring that down to $750, Your Honor.
Okay, I'll bring it down to $750 on count 4.
Thank you, Your
Okay.
Honor. Also, if we could have an order to put him in SAP.
Yes, absolutely. Okay.
Thank you.
I'm gonna maintain the bonds on the other counts already. Okay. All right, Devonte Jones.
Your Honor, he's coming.
Okay.
Hi.
All right, Mr. Jones, you've been arrested for aggravated assault with a deadly weapon. Based upon the allegations in the probable cause affidavit, I do find probable cause for the arrest. State, does Mr. Jones have any priors?
He has just 1 prior misdemeanor for possession of cannabis, Your Honor.
Okay, defense?
Yes, Your Honor. He has a job right now. He's working hard. He can afford at most a $2,000 bond. The prior that they just cited is in no way relevant to this case. Ideally, if it goes beyond $2,000, we'll be holding him in on a no bond hold, essentially. So, if there's any way that we could cap it at 2,000, so there's a possibility of him getting out.
Okay, state, what's your recommendation?
Your Honor, I would go along with the $2,000 bond, but I'd ask for him to be placed on pretrial supervision with a GPS and he'd have no contact with the victim.
Okay, I'm gonna set bond at $2,000 with a special condition that he be on standard pre-trial. Special condition, no contact with the victim, no return to the incident location, and you cannot possess firearms during the pendency of this case.
Thank you, Your Honor.
Okay. All right, Michael Lewis.
Hi, I'm sorry, Your Honor. I can't tell what this is charged under. Is it a felony or misdemeanor?
It's a felony. It's charged as a third-degree felony.
Okay.
All right, and he already has a $750 bond, so I'm gonna maintain that bond plus no return if you do bond out, Mr. Lewis, to the incident
thank you.
location. All right, thank you. And I do find probable cause for the arrest based upon the allegations in the probable cause affidavit. Okay? All right, Keith Upham? All right, good morning, Mr. Upham. You've been arrested for one count of petty theft, that's as a third-degree felony, one count of resisting without violence, and then another count of petty theft, which is currently charged as a third-degree felony. Based upon the allegations in the probable cause affidavit, I do find probable cause for the arrest. It looks like you already have bonds set on count 1 and 3 of $750 each. So I'm going to maintain those bonds, and I'm going to set a $100 bond on count 2, with a special condition that if you do bond out, you are not to return to the incident location.
Okay, Your Honor, if we could have his head checked and make sure that there's photos taken of the entirety of his head for bruises.
Absolutely.
Thank you. And if there's any way that we could bring down that for count 2 from 100 to 50.
Okay, I'll bring it down to
Thank you.
$50 on count
Thank you.
2. You're welcome. All right, Michael Green? Okay, Mr. Green, you've been arrested for one count of petty theft, one count of grand theft auto, one count of leaving the scene of a crash involving damage to property, attaching a registration or a license plate not attached, and operating without a valid driver's license based upon the allegations in the probable cause affidavit. I do find probable cause for the arrest. It looks like you already have a $1,000 bond on count 2. State, does Mr. Green have priors? Thank you.
It has a 2017 burglary battery out of West Palm Beach where he was adjudicated, a robbery with a weapon where he was adjudicated in West Palm Beach in 2017. And he has some juvenile priors that he was adjudicated delinquent.
Okay. Defense, do you have anything to add?
Your Honor, on the grand theft auto, if we could please bring it down to $750. He was in state's custody at the time, so. Also, Your Honor, on, the petty theft, I don't know if this is charged as a misdemeanor or a felony.
It's currently charged as a misdemeanor.
If we could put that at $50, as well as, leaving the scene at $50.
Okay. All right, I'm going to set bond on count one, at $250. I'm gonna maintain count two at $1,000. I'm gonna set count three, which is the leaving the scene of an accident, at $250. And then I'm gonna set count 4 and 5 at $50 each. Okay.
Your Honor, can you bring down counts 4 and 5 to $25?
Sure.
And also, Your Honor, can you bring down counts 1 and 3 to 200?
I believe that on count 1 and 3, the $250 is appropriate. So it'll be $250 on count 1, 1,000 on count 2, $250 on count 3, and then $25 on count 4 and $25 on count 5. All right, thank you.
Thank you, Your Honor.
All right. Bradley Demps. Good morning, Mr. Demps. All right, you've been arrested for driving while license suspended, which is currently charged as a third-degree felony and one count of attaching a registration or license plate not assigned. You already, based upon the allegations in the probable cause affidavit, I do find probable cause for the arrest. You already have a $750 bond on count 1. I'm gonna set count 2 at $50.
Your Honor, can we bring that down to $25?
Sure.
Count 2. Thank you.
Okay. All right, Jeremiah Wilbert Brun Garvin,
Medical reset.
okay? And then Jeffrey Orris.
Shows his main jail. There it is.
Oh, there he is. All right, Mr. Orris, you have been arrested for 2 no bond cases out of Judge Colliera's division and count 3 grand theft auto. Based upon the allegations in the probable cause affidavit, I do find probable cause. I'm going to maintain the no bonds on count 1 and 2, and I'm going to maintain the $1,000 grand theft auto on count 3. You'll see Judge Colliera, and then you can address this with him.
When do I go to court?
Your Honor, when does he go to court?
I don't have a future date on this one for Judge Colliera. Yeah, let's see if we can check on a future date for you.
Thank you.
On two burglaries.
Calendar call on the count 1 and 2 is set for February 21st. And then because this was a capias, he's gonna probably be brought in to be arraigned, I would assume, shortly.
It's probably gonna need to be set on his docket for set new dates. And I
He hasn't
don't
even,
think
it was a not in custody, so he's never actually
Oh.
been to that court, so he actually be arraigned, so I would presume in the next week or so.
Okay.
But on the pending case that's been tracking, it's February 21st.
Okay, all right, so he should be set hopefully in the next week or so for the new offense. And then on the one that's tracking, I guess it's in February, okay?
Yes, Your Honor. I'm going to ask on count 3, the grand theft auto, can we please bring it down to $750 because he's already held it on the no bonds, to make it possible that eventually he could get out.
See, what are his priors?
As the pending burglary structure before Judge Cora, misdemeanor possession, a robbery, sudden snatching, no weapon where he was adjudicated guilty, resisting without violence in 2015, burglary conveyance in 2015, 2 counts of that where he was adjudicated guilty, and a resisting without, another resisting without violence, and a battery on a probation officer, a burglary of a dwelling, 2012, and a possession of burglary tools, 2012, and several juvenile priors as well.
Okay, at this point, I'm gonna maintain the $1,000 bond based upon Mr. Orris's priors for theft-related offenses, for property crime offenses, okay? Thank you.
Okay, yeah, Your Honor.
All right, I think that's all I have. That's all, right? Okay, and we're off.
Yes, Your Honor.
All right, thank you.
Thank you.